Are you ready for me to drop some knowledge on you? Well, here it goes. Most of the callers we receive that are not the breadwinner, not the financially superior party, ask us, how do I get attorney's fees? How is my husband going to pay? How's my wife going to pay? How is my scandalous ex going to pay for this entire lawsuit? My answer is usually that they are not going to pay for it. Having said that, here's the knowledge that you may need. Florida's statutory law provides the court, your judge, may from time to time, after considering the financial resources of both parties, order a party to pay a reasonable amount of attorney's fees for maintaining or defending any proceeding for divorce, whether it's for enforcement or modification proceedings and appeals or the original action itself. The key language, after considering the financial resources of the parties. If your ex makes substantially less than you and you are the petitioning party, do you really anticipate receiving attorney's fees from them absent some misconduct, rule breaking, or court violations that are sanctionable? And if you are the party that needs money and you go to a temporary hearing and the other party makes more than you, but they make, let's say, $30,000 a year, you make minimum wage, what ability do they have to pay? If the financial resources of the parties are commensurate and it's tough litigation and neither party has accepted a settlement, attorney's fees might not be able to be awarded even if a judge would prefer to, unless there is sanctionable conduct, a failure to participate in discovery, for example, filing frivolous motions that are vengeful is another example. Continuing, in those cases where an action is brought for enforcement, and always look for that and before you run straight forward into a proverbial wall, the court finds that the non-compliant party is without justification in the refusal to follow a court order, the court may not award attorney's fees and costs of the non-compliant party. In other words, if you have justification for not following the court order, the likelihood is your behavior is not willful and it's not something that is itself to be construed as misconduct. Continuing, an application for attorney's fees shall not require expert testimony. So, what does it require then? We look to the statutory law and we look to case law. Case law provides in assessing a request for attorney's fees, the trial court may consider relevant factors. For example, how long your case has been going on, the merits of each respective position. Is somebody asking for equal time sharing and you're asking for nothing? Whether the litigation is brought or maintained primarily to harass, or whether a defense is raised to frustrate or stall, and the existence of any prior or pending litigation. Mainly, this, much like an award of alimony, depends on the parties' respective financial resources. Again, the court may, from time to time, after considering the resources, order the payment of attorney's fees. That language appears throughout everything. This is primarily statutory based. So let's take a couple of examples to tease this out to wet your whistle. Example number one. Suppose that husband and wife have been litigating for 3 years. The wife makes $150,000 a year. The husband makes $125,000 a year. Both parties have filed motions for enforcement and contempt. Both parties have had unclean hands with discovery, and both parties ask for attorney's fees. What incentive is there for the court to award those fees? Let's take a different case. One party is always on time with their discovery. One party has offered to settle the case a dozen times, and the other party resists settlement, and the other party is consistently late or hiding documentation, and the other party makes more money. Well, then the court might have sufficient reason to award attorney's fees. It is astonishing how often certain litigators ask for attorney's fees in cases where there's no reasonable grounds for it. I suppose if you do not ask for it, you're likely not to receive it. On the other hand, to me, that seems more like a tactic than it does sound reasoning with a great undergirding and a foundational basis, and I would advise against it.